Welcome, everyone. Thanks for joining us. This is the Corporate Counsel Institute 2021 CLE. I'm Sterling Spainhour, and I am hosting with Lynette Smith. We're excited to have everyone join. We've got a lot of great, timely topics, I think, for this CLE over 3 days, as well as just a great group of panelists who will be talking to you about a number of different things. So I know you didn't join to hear either I or Lynette speak. So with that, I will kick it off to one of the most timely topics, which is hot topics in employment law, which I imagine there are a couple things going on right now in employment law. And so I'll kick it to Whit and Rebecca. Thanks, guys.
Thank you, Sterling. Make sure I've got the screen sharing going all right. All right. Hello, everyone. Welcome. It's a pleasure to be here. Thanks to Lynette and Sterling for inviting us to serve on this panel and talk to you about things that we talk about amongst ourselves all the time. I want to introduce my co-panelists, my good friend and law partner, Rebecca Shanlever, and my good friend and former colleague, Leslie Luck, who is now the Senior Vice President and Assistant General Counsel at Global Payments. We've got a limited time today, so we are going to dispense with the perfunctory reading of bios for all of us. But I know that you want to have confidence in the panel that's speaking to you today. And so I did want to offer up just one little testimonial that I have. I don't know how well you can see it, and it may be a little bit backwards on this screen, but this is a testimonial by someone who has known me his whole life. It was done by my son when he was about 4 years old, and I think it's going to really put you all at ease as to the quality of panel that you have today. It says, "My dad is strong as a rock. My dad is funny as a monkey, as handsome as a king, but here's the real kicker that I think you're going to enjoy. My dad is as smart as a cheetah." So if you had any concerns about anything, I think that should put them to rest. I am certified as smart as a cheetah. I also happen to know that my co-panelists, I know that Rebecca Shanlever is an avid runner, and I know that my former colleague, Leslie Luck, actually ran track at Columbia in college. So I feel safe to say that all three panelists you have today for this session are all as smart as a cheetah. And so you can take that to the bank. The agenda we want to cover today is it's hot topics in employment law. I think we all know there's really only one truly hot topic right now, and we're certainly going to dive into that in just a minute, and that is federal vaccine mandates and the accommodation process that goes with some of that. And so that'll be our first topic. Also, we will be covering an update on restrictive covenants in Georgia and some new trends and developments on that, a lot of that is some very recent case law that we think you might find to be of interest. And then we're going to spend the last few minutes talking about some developments or potential new developments in conditional certification of collective actions in FLSA cases. And so those are our three main topics today. But first, we're going to kick off with a quick update on a matter that may not be super hot and timely today, but it sure was a month ago when we had to submit our written materials. And that is, Rebecca's going to give us a quick update on Aaron Rodgers.
All right, everybody. Thanks for participating. It looks like we've got a great crowd. One last just administrative item. If you have any questions as we go through the presentation, we'll try to maybe jump in and answer some of them as we go, or certainly answer them at the end. You can use the Q&A function to do that. and not the chat function. All right, so yes, to Aaron Rodgers, we're going to start out like all good CLE presentations do with a case study. Usually we have to get creative and make up these hypotheticals on our own, but thanks to the Green Bay Packers, we have the perfect real life fact pattern ripped from the headlines in the Twitterverse. It involves the COVID vaccine, but so much more related to employment law. For those of you that haven't followed, the NFL's requirement on COVID is kind of like the OSHA standard for private employers, which we're going to talk about. You get vaccinated or you undergo regular testing and follow more restrictive protocols, wearing a mask at all times and other things like that. So the Packers knew that their star quarterback, Aaron Rodgers, was not vaccinated, but he made some misleading comments to the media. He said that he was immunized, whatever that means, and he was also walking around without a mask in a lot of places because the Packers had lifted some of the unvaccinated protocols just for him. So people understandably believe that Rodgers was vaccinated. Well, so what? What happens next? Predictably, he tests positive for COVID. That's fine. That happens to unvaccinated players too. That meant he had to miss work like anybody else who has to quarantine. And guess what? The Packers lost to the Chiefs. As if that wasn't bad enough, he had, of course, violated the league's COVID protocols. He went to a couple of events unmasked, even though he was unvaccinated. So what does the NFL do? They fine him $15,000, probably not a lot of money to Aaron Rodgers. Because guess who really got in trouble? His employer, the Packers. The NFL fines them $300,000 for not making sure that Aaron Rodgers followed the protocol. All right, so for employment lawyers, here's where it really gets interesting. 3 other players on other teams violate the league's COVID protocols too. Does the NFL fine them? Yes, but it also suspends them for 3 games each. Are those players white like Aaron Rodgers? No, they're all African American. Their conduct, when you dig down deep into what they did versus what Rodgers did, it might be different enough to justify their different treatment. But at the very least, the league is now facing additional perception issues that were frankly already there. And all you have to do is check Twitter for Aaron Rodgers and COVID suspension, and you'll see what the league is facing. So this just, in a nutshell, demonstrates what we're going to talk about today. The vaccine mandates themselves, they're just the beginning. Like any other employer policy or any other employer discipline, we have to apply it uniformly, the same to anybody. I'll spare everybody the real breaking news on Rodgers. It involves COVID toe, and we'll just dig into the latest on vaccine mandates.
Thank you, Rebecca. Now we're going to dive into federal government vaccine mandates, updates, and strategies. What we're going to look at is sort of 3 different flavors of vaccine mandate for 3 different groups of employees. And we have these organized in such a way, you start off with sort of the smallest group of employees, and then the government kind of expands it to try to cover more employees. And then, of course, at the end, with the OSHA mandate, the government is swinging for the fences to try to cover a much greater number of employees with these mandates. There is a healthcare worker mandate that's also been administered by CMS, but that's not within the scope of what we're covering today. So let's talk about this first federal mandate, and that's the one that's enacted by Executive Order 14043. That was signed by the President on September 9, 2021. It applies to employees of the executive branch, that is Article 2 employees of the federal government. The president does not have authority to impose by executive order restrictions on Article 1 legislative employees or Article 3 judiciary employees. But the president or the executive branch for Article 2 is like the employer. And so the president can act like an employer and mandate vaccines via executive order, just like many companies, private companies had with their own private mandates for employees. And you'll see that, you know, there has not been any, at least not that I'm aware of, any litigation involving this executive order and the mandate that applies just to the executive branch employees. So this covers about 1.8 million civilian employees. And of course, there's also a military mandate that covers about approximately 2 million military employees, military members in related positions. So with this executive order, we've got about 4 million employees that are covered under the executive branch. Now let's put that in context for a second. In the United States, the total US civilian workforce, so not including military, but civilian workforce is about 160 million employees in 2021. You know, it's an estimate, but it's right around that number. So with this first executive order that applies just to Article 2 executive branch employees, what we see is, you know, we're really covering only about 1% of the workforce in the United States, and so it's a modest coverage. So the government says, how do we take that 1% and broaden it? How do we cover more people? And what we see is this next executive order, 14042, and this actually says the Safer Federal Workplace Taskforce was created by this executive order. It actually was not. It was actually created on the first or second day of the administration back in January of 2021. But what this executive order 14042 did was it directed the Safer Federal Workforce Task Force to provide guidance to federal contractors on practices and requirements for its employees. So how can we cover more employees? Well, there are thousands and thousands of federal government contractors in the United States. And so this executive order and this mandate applies not just to employees of Article 2 under the executive branch. It covers employees of contractors and subcontractors of the executive branch. Now, not all, we'll cover that in a minute, but it's quite a big number. It's estimated that there are about 4 million employees of federal government contractors and subcontractors. And so what this executive order does for contractors, for covered contractors, is it requires vaccination for all employees of a federal contractor or subcontractor, unless the employee is legally entitled to an accommodation. We'll talk about accommodations in a few minutes, but generally we're talking about disability or religious accommodations. And so unless there's a legal entitlement to not be vaccinated, subcontractor and contractor employees are required to be vaccinated. Under this executive order, there is no testing exemption, and there's no exemption if you have antibodies from a prior infection or prior sickness. So there is no exemption under this for contractor employees. Employees, covered contractors and subcontractors, their employees have to comply with CDC mask policies, which sometimes, given the circumstances on the ground, can require masks and distancing, even for employees who are vaccinated. For those of you who work for federal contractors, you know from your affirmative action work that there's always an affirmative action officer that's required of every covered contractor and subcontractor under Executive Order 11246. That's the Federal Affirmative Action Executive Order. And this executive order likewise requires contractors to designate an official who is responsible for complying with the executive order in terms of vaccinations and in terms of record keeping and monitoring and ensuring compliance. And so that's another part of this executive order that some of you will be familiar with from your affirmative action work. This was originally required to go into effect, and the vaccinations were required to be done by December 8th, which coincidentally is today, but that has since been pushed back. And the last extension that I've seen is now January 4th of next year. So there is some additional time that has been added on this. Interestingly, and this will be relevant when we talk about some of the court cases in just a minute, the vaccination requirement for contractor and subcontractor employees applies to all covered contractor employees, even if they work outside exclusively, and even if they work at their home all the time. We'll see in a minute that one of the courts who has ruled on this latched onto that. Now, I keep saying covered contractor, and I think if you are a federal contractor, you know how the affirmative action program works. There is an executive order that imposes that, but really the obligation to contractors is based on a term or a series of terms that are written into federal contracts. And that's really what takes the executive order and puts it in an enforcement place for contractors and subcontractors. And so just like that that affirmative action language has to be written into federal contracts to be applicable, the same is true here. The president can issue an executive order, but the terms of that executive order are enforceable against contractors and subcontractors only when it's in their contract. And so the language of this new executive order says that these new requirements are deemed to be included and shall be included in all federal contracts that are awarded after November 14th, 2021. Okay, so if you are a federal contractor and you are working on a contract that predates November 14th, 2021, you may not be covered by these new requirements. However, earlier contracts which are renewed or have an option or are extended after November 14th are also deemed to be modified contracts, and the executive order language is deemed to be included in those. So if you are a federal contractor, just make sure you check with your legal counsel and figure out whether you're bound by this new language and how it would apply to you. Let's talk for a minute about the legal status of this federal contractor executive order vaccine mandate. And this is hot off the presses. One of the cases just came out yesterday. But about 8 days ago, a district court judge in Kentucky enjoined enforcement of this vaccine mandate for employees of federal contractors. And based on the parties in that case, the injunction was put in place for just 3 states, Kentucky, Ohio, and Tennessee, because those were the 3 states that had joined in the litigation. And basically what the court said is that the president, with this executive order, has exceeded the authority granted to him under the Procurement Act by Congress to regulate procurement of resources that the federal government needs. 2 interesting points that the court in this district court in Kentucky latched onto was in talking about this concept of overreach of the executive order, the court took note of two things. One, it said the order expressly applies to employees even who work at home with no risk, who work at home exclusively with no risk of spreading the virus to other contractor employees. And that didn't sit well with the court in Kentucky, and sort of validated for that court this notion of overreaching. And then the court took sort of an unusual hypothetical and said that this would also, if the court approved this, then the government could impose other types of health-related restrictions on contractors and subcontractors and their employees. And the example that the court gave was that the federal government could tell federal contractors that it is not entitled to hire employees who have a body mass index above a certain level, with the theory that if a health concern is enough to be pulled in by the Procurement Act into a executive order, why stop at vaccines? And the government could impose restrictions on hiring employees who are overweight by some measure. So that's sort of an interesting take on that. Now, that was just a week ago, that Kentucky case. Just yesterday, in a case, an order issued out of the U.S. District Court, Southern District of Georgia in Augusta, a case filed by the state of Georgia against the president, and the judge, Judge Stan Baker, issued an order essentially agreeing with the Kentucky order that came down a week ago, and saying that the Procurement Act was intended to address administrative and management issues in order to achieve a system of making, pursuing things for the economy and efficiency, and that a vaccine mandate is just, a regulation related to public health and not procurement. And so the court down in Augusta determined that the state of Georgia and its lawsuit was likely to prevail on the merits and issued an injunction. Now, the court in Augusta had allowed a private company with offices all over the country to intervene in that case. And so because of that, Judge Baker in Augusta issued a nationwide injunction against enforcement of this executive order regarding federal contractors. And that was issued just yesterday, and so hot off the presses. Now, enough about contractors. I'm sure a decent number of you are not contractors, but hopefully that was still of interest. Now, the next question for the federal government is, how can we go bigger? With federal contractors and their employees and Article 2 employees, we're still only up to about 6 million employees that are covered by these first two mandates. So that's still only less than 4% of the civilian workforce in the United States. The government wants to go bigger with these mandates, and how does it do so? And for that, I'm going to turn it over to Leslie Luck to take us through the OSHA Emergency Temporary Standard.
Can you hear me, Whit? Just want to make sure.
We've got you, Leslie.
Okay. All right. So I'm here on audio. I'm not sure if the video is coming through, but I promise you I look exactly like that picture that's in the presentation, though I'm questioning whether today I am as smart as a cheetah. So as Whit mentioned, the government wasn't quite satisfied on that they had reached enough individuals in order to get them vaccinated. And so they introduced the OSHA vaccine mandate. And that's the mandate that has received the most attention because it would impact the most employers. And most of you all probably know it as the vax or test requirement. So today, in the next 10 to 15 minutes or until Whit cuts me off, I will talk about who's covered, what are the key requirements under that requirement, what's the status, which is probably why a lot of you are here today, because you want to find out what's happening and how much do I need to do between now and the compliance deadline of January 4th of next year, and how to deal with accommodation requests under the requirement. Obviously, you can't cover every question you likely have about the requirement, but I would point you to OSHA's website. They have developed pretty extensive FAQs that answer a lot of the questions you will have as you are getting into compliance. Of course, you can also read the 400 and so pages about the ETS, but I would, most of you would probably prefer to look at the FAQs instead. So let's just start with who's covered. So you are covered if you're a private employer with 100 or more employees company-wide. That also includes employees that are working part-time for you, and that also includes employees that are working remote, even if they are working 100% remote. But as with respect to which employees does the actual requirements apply to, they only apply to employees that are actually coming into the workplace. So employees that are coming into a physical location. So employees that are exclusively working from home are not covered by the requirements, and also employees that exclusively work outside are not covered by the requirement, which is different from the federal contractor requirement, which does include both of those types of employees within its requirement. As I mentioned, it is a vax or test requirement. So as an employer, you can have a requirement, subject to request for accommodation. You can have a policy that requires all of your employees to get fully vaccinated. You can also have a policy that gives employees the option, if they don't want to get fully vaccinated, that they also have the option to subject themselves to weekly testing and masking. You can also combine those requirements. So for example, you could say for a segment of my employee population, for example, employees who are customer facing, I want to require that all of those employees are fully vaccinated, subject, of course, to any accommodation request. But for employees that are not fully, that are not customer facing, I'll give those employees the option of either being fully vaccinated or testing and wearing a mask when they're in the workplace. Of course, if you do decide to provide different treatment to different parts of your employee population, you want to be thoughtful and think about not only internal PR issues, but possibly, for some of you all, you may have some external PR issues as well. And two last things I'll mention about that option. So if you give employees the option of testing and masking, one is that it's both requirements will apply. So they will need to wear they will need to undergo weekly testing and also wear a mask when they are in the workplace. And then the second is the one open question that a lot of us were waiting for guidance on as we knew that the ETS was coming, was about the cost. Can I shift that cost to the employee? And the answer is that yes, you can shift that cost to the employee. Again, two things to think about there is one, obviously you want to be thoughtful about, what are the internal issues you're going to have to deal, morale issues possibly you're going to have to deal with if you shift that cost to the employees. The second legal issue that you need to be aware of is that there are many state laws that will not allow you to shift certain employer costs to employees. And so you need to check the state laws where you have employees before you do that to see whether you're prohibited from doing that in certain states. I'm sure a lot of us can come up with pretty creative arguments as to why it's not an employer requirement, right? Because you are giving employees the option. They could always choose to get fully vaccinated, but obviously that's untested. There's no case law currently on that issue, and you may not want to be the employer that is forging new ground and creating case law on that issue. We'll move to the next slide. Wait, yeah, thanks. So I'm going to cover 4 of the key requirements under the temporary standard. The first requirement is that you need to have a written vaccination policy. I know a lot of us have been living and breathing this for many, many months, even before the standard was published, and have developed COVID-19 policies and have those policies currently in place. You don't need to implement a new ETS specific policy, but you do need to make sure that your whatever policy you roll out does comply with the specific requirement in the standard. If you don't have a current policy, OSHA actually has provided a template of a policy, and it's actually a pretty good starting point. Obviously, you'll need to modify it to apply to your workforce, and depending on whether you give employees the testing option or not. The second requirement, and this is really the requirement, again, I'll talk about this day and the current status of legal challenges in just a minute, but the second requirement is the requirement why most of us have decided that we cannot take a wait and see approach as far as getting into compliance with the standard. And that is that you must request from your employees their information on their vaccination status. You need to record that information, and you need to maintain records of your employee status, at least while the ETS is in effect. 2 specific things I'll mention there. One, if an employee tells you that they are fully vaccinated, they need to provide proof. It's not enough for them to check a box and tell you that they've been fully vaccinated, even if they give you the details. They have to give you the details about their the vaccine, and they also need to provide proof. And for most cases, if an employee uploads a copy of their vaccination card, that will satisfy that requirement. The second thing you should be aware of there and be thoughtful about is how you are actually going to report on that information. You'll want to work very closely with your HR ops folks, your HRIS system, whoever handles that, whether it's in-source or outsourced, because under the state reporting requirements, and those reporting requirements have very, very short deadlines. One can be if OSHA comes knocking on your door, you've got to provide certain records to OSHA within a 2 to 3 day time period. But even shorter time period than that is an employee under the standard can ask you, the employer, to provide them certain information about the vaccination status of the individuals in the workplace, obviously not by name, but on an aggregated basis. And that timeline for getting that information to the employee is really short. It's a 24-hour turnaround time period. So again, you want to work very closely with your folks to make sure whatever method you use to record and maintain that information also allows you to report out on that information very quickly. The last 2 key requirements that I'll talk about are somewhat related. The third key requirement is that you need to provide employees with up to 4 hours of paid time off in order to get vaccinated. And that is 4 hours in addition to any leave time that employees currently, that you allot them today. And that's 4 hours per dose of the vaccine. So if they choose to get the Pfizer or Moderna vaccine, they would have up to 8 hours of paid time off in order to get vaccinated. And that is, you can't decrement any vacation or sick leave time that employees currently have. You have to give them 8 hours of additional time in order to get vaccinated. Similarly, you also need to provide employees with 4 hours, with paid time off, reasonable paid time off in order to recover from the side effects of the vaccine. Unlike the other requirement, you can, if you provide your employees with sick leave, or if you provide them with a PTO bucket that includes sick and vacation leave, you can require employees to use that time in order to recover from the side effects of the vaccine. And the last thing that's mentioned on the slide, probably not a surprise to anybody that's listening in, is that there are financial penalties for failing to comply with the requirement, and similar to penalties for other OSHA violations, they range from about $13,000 to about $140,000 or so, depending on whether it's a willful or a serious violation. So Yep, thanks, Whit. So this is the part that probably everybody's listening in to hear, is what is the current status of the legal challenges? And my disclaimer here is that this is only current as of the moment I'm giving you this information. As you all know, things have been quickly evolving. A lot of us have been rarely having the L&E stuff where you're actually looking out for the breaking news alert, like the news alert that came yesterday about the federal contractor mandate. So what's the current status? So as of today, the ETS is currently stayed. So as I mentioned, just as soon as the ETS was published, multiple challenges were filed, and those of us who were watching it knew that that was going to happen. Getting a stay in place happened much quicker than a lot of us expected. So the ETS was published as of November 5th, made effective as of that date. As of November 6th, the Fifth Circuit had issued a stay. About a week later, they extended that nationwide stay. Won't get into the details of the decision, but if you want to read what's likely to be in the Sixth Circuit decision when they get to the issue, that Fifth Circuit decision is a good case to read and provides you with a pretty good roadmap of the arguments that will be at the Supreme Court when this gets to the Supreme Court. So right now, we have a stay from the Fifth Circuit. Because there were multiple challenges, all of the cases were consolidated into the Sixth Circuit. And we're with the Sixth Circuit Court of Appeals. This all moved quickly because in order to challenge an OSHA ETS, you do not need to go to district court. You can go straight to the Circuit Court of Appeals. So now we have multiple challenges that have been consolidated into the Sixth Circuit. There are approximately 33 or so petitions that have been consolidated into this one case. And so hard to say how quickly that will be resolved given the number of challenges that have been consolidated. The next big date to watch in the Sixth Circuit is actually coming up on Friday. So as soon as those cases were consolidated into the Sixth Circuit, OSHA filed a motion to dissolve the current stay that is in place. The briefs are due on that as of Friday, and so hard to say how quickly that will happen, whether that the Sixth Circuit decides to extend that stay, whether it decides to lift that stay, but hopefully within the next week or so, we will get a decision on that part of it. Once that is decided, then we'll move over to discussion on the merits. And again, that will probably take some time. I think if the stay is extended, those of us who are watching it pretty closely believe that January 4th compliance date, which is coming up pretty quickly, is no longer at play, but hard to say how quickly thereafter it'll get resolved. And I'm curious, I know from Whit and Rebecca, I know that the general guidance is to get into compliance, particularly with respect to getting employees vaccination status, but do you all have any clients that are taking a wait and see approach with respect to the legal challenges?
Well, I can tell you that most of the clients that I'm talking to are have a lot of them have mandates already in place. I think they are taking a wait and see approach. Some of them on the technical compliance, the record keeping, maybe starting to do that, but not really in a panic about it. The idea that these dates are probably going to get pushed back again, and that there'll be some sort of grace period for record keeping. So, I think frankly, most of them are having mandates already in place anyway. They're kind of taking a wait and see on some of the technical aspects.
Yeah, and that's what I'm hearing.
I've got a few also, Leslie, and part of it is because I told them that they needed to raise all their exempt employees' salaries by about $15,000 6 years ago, and they did that and then didn't have to do it. So I think, there is a little bit of like, well, it's been challenged. Let's just wait and see what happens. I do have a lot of clients who were already maintaining, well, at least collecting information about vaccination status, almost conducting a census. And so what they'll need to do is, collect the actual records. But again, just sort of hoping that they will get some extra time to do that once it goes into effect.
Leslie, we've spent a lot of time on so many of these important new developments. So let's try to slide through these accommodation slides pretty quickly. It's not really much terribly new. We just kind of wanted to give some reminders, but while we slide into that and just try to get through those pretty quickly so we can get into the others.
Yeah, and so, the questions that a lot of employers have is, what if an employee says they can't be vaccinated, can't comply with the testing or masking requirements because of a sincerely held religious belief or because of disability? And just like you would evaluate any other request for an exemption from a workplace requirement where employee claims that they can't comply because of a disability or a sincerely held religious belief, you would apply that same process here. A couple things that I'll quickly cover if you want to jump to the next slide. Yep. So just, keep in mind that you don't need to just jump to the reasonable accommodation step of the process. You don't want to skip the first step, which is asking the employee to identify the underlying condition or religious belief that keeps them from complying with your workplace requirements. On the religious piece, I think some of you all may have seen that for the bargain basement price of $59.95 or so. Employees can actually get information to help document their sincerely held religious belief. I think if you pay a little bit more, you can actually even get some consulting. So just be aware of that. You may start seeing some things that don't necessarily look like they were actually prepared or drafted by the employee. But of course, you should follow the normal process you would in evaluating those requests for an accommodation. The last bullet point that, again, we don't need to go in much detail, but just keep in mind that there's a different undue hardship analysis that applies whether you're dealing with a request for an accommodation due to a disability or whether you're dealing with a request for an accommodation due to a sincerely held religious belief. And the standard for an accommodation based on religion is a much lower standard. Then if you want to great, thanks. The last slide. A couple things I mentioned again, no different than if you were evaluating any other request for an accommodation. One is that you get to pick the accommodation among many accommodations. So if your employer, even if employee has been working from home, if that accommodation will no longer work, you can decide that there is another reasonable accommodation that will satisfy the employee's request. Another quick point is you can also grant and revisit the request later. So if it's not an undue burden when you're initially evaluating it, you can decide that we'll allow the employee to have XYZ accommodation for X period of time and then revisit that later. And the last point, promise Whit, I will make is, which I've alluded to a little bit in the presentation, is remember that there are a lot of state laws, and these state laws are being enacted on an almost daily basis that apply to mandates. There's also state laws very specific on documentation that you can get from an employee to prove that they're vaccinated. And also there are a bunch of new state laws that are popping up that are providing additional exemptions to employees in addition to disability or sincerely held religious belief with respect to any vaccine mandate. So I'll stop there and turn it back over to you. Thanks, Whit.
All right, I think our next topic is mine. We're gonna do a quick sort of past, present, future update on non-compete covenants, focusing on Georgia, but addressing a couple of other trends as well. For the past, voters in Georgia approved this constitutional amendment changing the restrictive covenant law in Georgia over 10 years ago. And around that time is when Whit and I first had our first lawsuit with each other. We were not against each other. We were on the same side of the V, but had different clients. Since then, Whit and I both, and all of our fellow employment lawyers, have been telling clients it's going to take some time for cases to bubble up through the courts and for us to be able to give you some answers on this new law. It's been 10 years and we're still saying that today because it does take a while for these cases to get decided. So what we may talk about more today is what's unresolved. Here's what we do know, and this is sort of the biggest question that I get from my clients all the time, is because in the old days I could say if this agreement's too broad, if it covers too much geographic territory or lasts for too long, it's not enforceable. The court will, what we call, red pencil it and throw it out. What the law basically does, this new law, is allows a court to blue pencil an agreement. Blue pencil meaning you can remove the parts that make it unenforceable. You can't necessarily rewrite the whole entire contract for the parties, but you can certainly blue pencil it and take out the things that don't work. So what exactly does that mean when a court is faced with an agreement that's a little bit too broad under this new Georgia law? I'll give you an example. An agreement has a territory and says that an employee cannot compete with the former employer within that territory for a certain period of time. The first agreement, the territory is defined to say the following counties: Fulton, DeKalb, Gwinnett, Cobb. The employee never once set foot in Cobb for the employer, never worked in Cobb, only ever worked in Fulton, DeKalb, and Gwinnett. The court can simply strike with its blue pencil the Cobb County language in the agreement, and it works perfectly. It's plenty enforceable. It's plenty reasonable. We know now that the court in Georgia can do that. Couldn't do it before, but can do it now. What though if the agreement is written so that the territory is the 100-mile radius around the city of Atlanta, Georgia, or the headquarters of the company? That's a little harder for a court to just blue pencil. You can't just strike out a county or a zip code or some other portion of the language and make it reasonable. It's a lot more like rewriting the contract. The way that the Restrictive Covenant Act is written, it lets the court do that if it wants to, but it's very much discretionary. Courts have been doing it and they argue, well, we're just shrinking it down to make it reasonable. But it's still up to the judge's discretion. And what I have to tell my clients all the time is that leaves a lot of uncertainty because it depends on who your judge is, whether they're going to be willing, because they may do it, but they don't have to. what kinds of employees does the Restrictive Covenant Act even apply to? It's not every single employee. If you are a barista at Starbucks, it's probably not going to apply to you. If you are working behind the counter at Chick-fil-A, I know we've got some Chick-fil-A folks on the call, you're probably not going to be covered by the Restrictive Covenant Act, and a non-compete agreement, involving you would not be enforceable. There have been some really interesting cases where, employees argue, I'm not even covered. And there are some examples here. Some of these might surprise you. A hairdresser is covered. And that's because the hairdresser regularly solicited customers, and that's one of the categories of employees that is covered under the Act. A backhoe operator is not covered. That was a pretty novel argument by the former employer that the backhoe operator ought to be covered. But because this person, because the backhoe operator wasn't a key employee or a professional, wasn't a manager, didn't solicit customers, they were not covered by the law, and the non-compete was struck down. The backhoe operator got to go work for whoever she wanted to. And then the last one is a cake decorator who also sold cakes, and the former employer creatively argued that this was a sales employee, but simply taking orders and was not going to be enough to make this person covered under the sales provision. And decorating cakes, I should say the cake decorator in this particular case managed and supervised a couple of other employees, which is one of the other one of the other categories of employees that's covered, managers. But you still have to have input into hiring and firing, and just because you direct some work of other employees doesn't mean you're going to be covered. So this is how it shakes out in real life under the new law. I think Wood's got a couple of case examples he's going to share as well.
Let me unmute myself. I did want to go through a couple of unique covenant situations that we've seen in our office recently that I think are worth mentioning. We don't have to go into a great lot of detail, but we all know that Georgia law traditionally, with respect to covenants, has kind of looked at non-compete covenants, which really bar competition almost entirely or entirely in a specific geographic area. And then there's a non-solicitation covenant, which is very client-focused, but it only prohibits soliciting a client, not all work with the client. And we've all known over the years, as time has gone by, that this whole concept of geography with respect to jobs and competition is a little bit antiquated for a lot of jobs. And so what some companies have in Georgia have decided to do is try to figure out a way where they can get sort of the comprehensive protection of a non-compete, but with the focus of a non-solicit, the client focus of a non-solicit. And so what we've started to see on a few occasions is what I have started calling a client non-compete. That is a non-compete that doesn't say you can't work at all in a geographic area, but rather it's a non-compete that says you can't work with clients in a specific geographic area. And, there's a lot of arguments, and I've made a lot of them, about why that's not a valid covenant or shouldn't be under the Georgia RCA. But I'm here to tell you that in March of 2021, in a case in the Northern District of Georgia, Judge Grimberg did issue an order in the case, it's Gallagher Benefit Services v. Campbell, in which the court said, no, this kind of covenant is okay under the Georgia law because it's, even though it had a broad geographic territory of the United States, the court said it's, quote, limited to only a specific list of clients. So it had the geography, but it was limited only to specific clients. And the court in that case, and it's really the first time I've seen this, said, no, that covenant is okay under Georgia, under the Georgia RCA. I'm currently litigating a case with a similar covenant that I'm arguing against. And it's different in some key ways that we think are very important. But I think it's worth keeping an eye on this trend of this client non-compete trend because it's it's starting to get a little bit of traction in some courts. There was a court in Alabama that said no, applying Georgia law, but there's at least one case in the Northern District that has said yes. So I wanted you to be aware of that. Another issue that I've had, or that we've all had recently in some of our litigation is client solicitation and social media. If you've been involved in restrictive covenant litigation in recent years, you know there's a lot of action around this issue of what's a solicitation and what's not. And perhaps more important for the people on this call, there's a lot of discovery that's being done on that issue and a lot of fees that clients are having to pay on that issue of looking at all the communications and sorting out what is a solicitation and what is not. A lot of plaintiffs in covenant cases are trying to look at social media and come up with solicitation arguments applying to that. And so I want to just throw out a couple of sort of general rules that we've seen as we've researched these social media cases nationwide. And really the takeaways from our research are this, sort of the usual rules about solicitation still apply to non-solicitation. And that is basically if it's targeted specifically to clients, it's more likely to be a solicitation. And if the communication has a plea or a request or a demand or an ask, that's sort of a second key thing. And so if you're using social media and you're using it to target clients and to make requests, then that's something that very well could be a solicitation. In this Kennedy versus the Shave Barber case that Rebecca talked about with the hairdresser, that's exactly what the employee did, was imploring the court said, quote, she was imploring existing clients to refer new clients to receive discounts. So you've got targeting to existing clients and you've got an ask or a request, and that was found to be a solicitation. But the other trend sort of on the other side of the coin is this. If you're not doing those two things and you're just status updating, right? That's really important. We see that a lot in LinkedIn. Status updating, the sort of the trend of cases that we've seen shows that status updating is not usually going to be deemed a solicitation. And indeed, we've argued in court recently that not updating your status couldn't be the right answer because you're then holding yourself out as still being employed with your former company. And that's not good for anybody. So I think status updates are generally trending towards being fine and safe and not solicitations. Procedural nuances. This is going to be hard to do quickly. So let me try to just sum this up like this. I think most of us who've done covenant work over the years know that choice of law, Georgia courts have for many years said we're going to apply Georgia law if following another state's law violates our public policy. About 10 years ago, the same result essentially came about with forum selection clauses. Contracts that have a term that says this case has to be litigated in a certain forum. And this case, Bunker Hill, that came out about 10 years ago, sort of lays out the pathway for how a litigant, an employee in particular, can defeat that forum selection clause. The key takeaway here for this third bullet point is understand this. Bunker Hill, this forum selection avoidance practice, so far has not found its way into the federal court system. It's available in state court. It's well established in state court, but I believe it's an Erie Doctrine issue. Forums are procedural, choice of law is substantive. And so where your case exists, whether there's diversity, whether it's in state court or federal court, under Bunker Hill can have a huge impact on your forum, which can then in turn have a huge impact on your choice of law. So really looking at this diversity issue on the front end and figuring out where your case is going to be is really important for thinking about whether Bunker Hill is going to be available to you for avoiding a forum selection clause. And now I'm going to turn it back over to Rebecca for a couple of quick non-compete updates.
Just to wrap up, because we are out of time, many of you on the call probably have operations in other states, and just know that the trend in other states, at least, is to restrict the ability of restrictive covenants to be enforced, restrictive covenants. So just make sure you check your local, and in some cases your local and state laws. In the last, I don't know, 3 years, I think we've seen at least 10 states try to limit the application of non-competes in certain circumstances to either how much money a person employees making over a certain amount, or sometimes in certain industries as well. So the quick takeaway there is just check your local and state law. What, you want to jump on to a quick closeout on FLSA?
Yeah, I will. And really, this is real quick. Anyone who's done FLSA litigation with collective actions knows that a lot of the action, a lot of the risk in the case comes about with that first step of conditional collective action certification. That's the decision on the front end that determines who gets notice, what the notice looks like, and it can really take what's a very small, very manageable FLSA issue and blow it up company-wide with opt-in plaintiffs and whatnot. And so what we've seen, and really what the law is here in the 11th Circuit, is that two-step class certification process is very lenient on the front end. That is, conditional certification is very easy for a plaintiff to get. And really the hard merits decision on Class D certification happens at the end of discovery. And what a lot of employers have seen over the years is, well, we've already lost. If we lose on this front end conditional certification, you've got notice going out to everybody, you've got hundreds or thousands of collective action opt-ins. And so there's some question as to whether there should be a more stringent process for this early certification. I mean, an example of this is, and this is something we've seen in a case that we have here, we've got a lot of employees who have signed arbitration agreements, and those arbitration agreements to say no collective actions. And the argument that we've seen in some